Good morning. The subcommittee will come to order. Without objection, the chair is authorized to declare recesses of the subcommittee at any time. Let me first of all thank all of you for your indulgence. This morning we had the enrollment signing of the Juneteenth holiday that was declared yesterday, and I am certainly ecstatic, but I also want to acknowledge my respect for this hearing and my role as chair, but my tardiness was not for any other reason for the historic enrollment signing of the Juneteenth Independent National Holiday Day. So thank you all as witnesses and my committee members for your indulgence. Thank you so very much. We welcome everyone to this morning's hearing on undoing the damage of the war on drugs, a renewed call for sentencing reform, long overdue. Before we begin, I'd like to remind members that we have established the email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members may want to offer as part of our hearing today. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. For those in the room, current guidance from the Office of Attending Physicians that individuals who are fully vaccinated for COVID-19 do not need to wear masks or maintain social distancing. Fully vaccinated individuals may, of course, choose to continue wearing masks based on their specific risk considerations. If you're not fully vaccinated, the Office of the Attending Physician requires you to continue wearing a mask and maintaining 6 feet of social distancing. I would also like members to mute your microphones when you're not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. I will now recognize myself for an opening statement. Today marks the 50th anniversary of the war on drugs, and the 1970s marked the start of a dramatic rise in U.S. prison population. Mass incarceration grew, developed, imploded, and continued. This has only increased and is unmatched globally, with over 2 million people currently incarcerated, even though the U.S. only accounts for less than 5% of the world's population. On June 17, 1971, President Nixon declared his new policy, war on drugs, in response to a rising tide of the use and/or trafficking of drugs. This policy became an engine for mass incarceration as it resulted in an increase of federal funding for drug control agencies, proposed measures such as mandatory and excessive sentencing laws, and yes, the now well-known and destructive no-knock warrants. The totality of these punitive measures do not increase public safety. Rather, it produces permanent harm and disrupts the entire equilibrium of justice. We examine sentencing reform through a punitive lens rather than rehabilitation. Consequently, a significant wave of destruction has amassed billions of dollars in human costs throughout communities of color while destroying families. I remember just a few years ago, under our former chairman of this committee, as the siege of opioids were facing us, we did a different approach. We did an approach of rehabilitation, treatment. What a difference. And I offered an amendment that this new approach would cover crack, cocaine as well. New thinking needs to be the call of the day. When looking back at the true reason for the war on drugs, several top aides within Nixon's immediate orbit have revealed that by getting the public to associate the hippies with marijuana, blacks with heroin, and then criminalizing both heavily, they could disrupt the communities. They would arrest their leaders, raid their homes, break up their meetings, and vilify them night after night on the evening news. They did so knowing that the false narrative would work, and it did. As ACLU says, the drug war has achieved only the harmful purposes President Nixon intended, disrupting, vilifying, and oppressing communities of color. I agree with the Leadership Conference that Congress must be bold to effectively repair the damage wrought by these overly excessive penalties. You know who else was caught up in all this? Juveniles, under 25, under 20, their lives off track because of the use of drugs or the co-opting of those who are engaged in drug use and or drug trafficking, juveniles, children, who got sentenced in 25 years, 30 years in that time. The impact of the war on drugs is still being felt today, as evidenced in the alarming number of individuals incarcerated under these laws, even 50 years later. According to the Federal Bureau of Prisons' own data, nearly half of all inmates are incarcerated on drug offenses. Every month, approximately 1,600 people are sentenced for drug offenses in federal court, most of which receive harsh sentences. In the 80s to 90s, we passed several legislations which continue to move away from rehabilitation and focus instead on excessive punishment when dealing with drugs. Several bills continue to emphasize the prison focus. For example, the Anti-Drug Abuse Act of 1986 implemented the initial 100-to-1 disparity and created mandatory minimum penalties for drug offenses, including life imprisonment. In the 90s, we passed the 3 strikes penalty that mandated a life sentence for anyone convicted of certain prior drug or violent felonies and incentivized states to adopt similar policies. In 1995, the U.S. Sentencing Commission called upon Congress to revisit these draconian mandatory minimum sentencing laws because of the racial disparities in cocaine versus crack cocaine sentencing. Congress, however, overrode the recommendation made. We must use and undo the damage caused by the war on drugs. In Terry versus U.S., June 2017, the most recent drug case before the Supreme Court, the court held that crack offenders who did not trigger a mandatory minimum are not eligible for a sentence reduction under the First Step Act of 2018. Justice Sotomayor concurs with Justice Thomas and essentially says that Congress has the necessary tools at its disposal to remedy the issue in Terry. I agree, and this is why I am working on legislation with the Senate, and we intend to introduce legislation in short order to address this issue in Terry. We're also delighted that other members, such as Mr. Jeffries, are working on legislation that is important to this discussion, and many other members on this subcommittee. In making its finding, Justice Thomas pointed to instances in which Congress has responded with proposed legislation for disproportionate ratios in how drugs of equal effect are treated differently. The court explained, and I quote, Senator Sessions and Hatch introduced legislation in 2001 to lower the 100-to-1 ratio to 20-to-1. Representative Lee led a similar effort in the House, but would have created a 1-to-1 ratio in H.R. 4545. As the Supreme Court has acknowledged, I've been fighting to change these disparities for over a decade, and I will continue to do so as we seek to end mandatory minimum sentencing, beginning with the drug mandatory minimums, and I reserve the balance of my time. It's my pleasure now to recognize the ranking member's opening statement, and that is the gentleman from Arizona, Mr. Biggs, for his opening statement.
I thank the Chairwoman, and appreciate all the witnesses being here today, both in person and remotely as well. I look forward to a robust conversation surrounding sentencing reform, and I believe it's the job of Congress to examine the efficacy of our laws from time to time to see if updates are needed. In fact, we should be looking, in my opinion, at our entire federal criminal code to see what changes need to be made. Shockingly, no one really knows how many federal crimes are in statute, but some estimates put the figure above 4,000. Keep in mind that at its inception, the United States Code included only 30 crimes. It has been nearly 40 years since retired Justice Department official Ronald Gaynor managed the last comprehensive attempt to count the number of federal crimes, and concluded, quote, "You will have died and resurrected 3 times," close quote, and will still not have an answer to how many federal crimes are on the books in the United States. And I would suggest that many of those are duplicative and irrelevant. Not even the Congressional Research Service or the American Bar Association are able to calculate the number of federal crimes. According to one analysis, legislators introduced 154 bills in the 115th Congress alone that sought to add more criminal penalties to the United States Code. And Congress is not even the most egregious culprit in this overcriminalization. The sheer number of regulatory crimes in this country is mind-boggling. I have stated there are more than 4,000 federal crimes in the U.S. Code. But there are also, astonishingly, more than 300,000 federal crimes throughout various federal regulations. That is absurd. Many of these crimes are already crimes at the state level, and that's exactly where they should be prosecuted. And last I checked, murder is a crime in every state, for instance. The saturation of criminal conduct prevents law enforcement from focusing only on the severe and dangerous federal crimes. Andrew McCarthy, a former federal prosecutor, said that time and money, quote, spent investigating conduct that is not inherently criminal are time and money lost to the thwarting of much more serious crime, close quote. Overcriminalization coupled with the left's desire to defund the police has real-world consequences. In New York City, NYPD data showed murders jumped by nearly 14% through March 28th of this year, the latest figures the department has made public, while shootings were up nearly 50%. The jump in crime came on the heels of New York City defunding its police department by $1 billion. In LA, homicides have increased nearly 36% from 67 to 91 through March 30th of this year. The increased homicide rate occurred after Los Angeles defunded its police department by $150 million. Detroit, Michigan suffered 327 homicides in 2020 as opposed to 275 in 2019, and aggravated assaults rose to 12,003 in 2020 from 9,467 in 2019. Detroit began defunding its police force in 2014 due to a citywide bankruptcy. And since 2014, the Detroit Police Department has been cut by 20%. As leaders, we should not be encouraging states and localities to defund their police. In fact, we should condemn it when we see it. That is why I was dismayed to see that the majority invited at least one witness who advocates for defunding our police. In sum, we know that overcriminalization has led to a backlog in our courts and an overflow of inmates in our prisons. It's duplicative, it's unnecessary, and quite frankly, in my opinion, it's unconstitutional. No one really knows how many federal crimes are in statute, and that is a crime in and of itself, rhetorically speaking. And then I will say also, generally crime had been in the United States had been trending downward over the last 30 years. Violent crime and property crime. But last year, the United States tallied more than 20,000 murders, the highest since 1995. No doubt the impact of COVID was there. But it was 4,000 more than in 2019. And 63 of the 66 largest police jurisdictions saw increases in at least one category of violent crime in 2020. I'm looking forward to a robust discussion that I'm sure we will have today. I appreciate the chair for convening this very important committee hearing, and I look forward to hearing from all the witnesses today. Thank you. I yield back.
Gentleman yields back. We'll now move to introducing our witnesses. Thank you very much, Mr. Biggs, for your statement. Ms. Rachel Barkow, that is on virtual, is the Vice Dean, and Charles Seligonson, Professor of Law and Faculty Director of the Center on the Administration of Criminal Justice at NYU School of Law. She's recognized as one of the country's leading experts on criminal law and policy. In June of 2013, the Senate confirmed Ms. Barkow as a member of the Sentencing Commission, where she served until January 2019. She's been a member of the Manhattan District Attorney's Office Conviction Integrity Policy Advisory Panel since 2010. Mr. William Underwood, as a senior fellow at the Sentencing Project, Mr. Underwood serves 33 of a 60-year sentence and life sentence in federal prison after being sentenced in 1990 under the then newly enacted Sentencing Guidelines of 1987 and the Anti-Drug Abuse Act of 1988. His mentoring of countless young men in custody attracted the attention of federal circuit judge who wrote to thank him for making a difference in the lives of people around him. On January 15, 2021, a federal judge granted his motion for compassionate release on an exemplary disciplinary record and found that he had transformed himself into a model prisoner and an American father. Today, Mr. Underwood works on criminal justice reform. Ms. Kiana Gibbons is an assistant federal public defender for the Eastern District of North Carolina. In addition to her federal criminal defense practice, Ms. Gibbons teaches and trains attorneys across the country on trial advocacy, emerging digital technology, and unconscious bias. Ms. Gibbons was the Albert M. Sachs Fellow at Harvard Law School, where she worked closely with clinical professors teaching and training in trial advocacy. Ms. Gibbons is a faculty member at the National Criminal Defense College and serves on the faculty for the Trial Skills Academy for Federal Defenders. Ms. Cassandra Frederick is the executive director of the Drug Policy Alliance. She has built and led campaigns on the overdose crisis and marijuana legalization. Ms. Frederick has been instrumental in grounding the national drug policy conversation around reparative justice and restitution for communities harmed by the war on drugs. Among other victories, Ms. Frederick was the architect of the campaign that cut the number of New York City marijuana arrests by more than 99%. Ms. Marta Nelson is the Director of Government Strategy, Advocacy, and Partnerships Department at the Vera Institute of Justice. She joined Vera in 2019 to research and write on sentencing reform, particularly sentencing involving people convicted of violent offenses. Prior to joining Vera, Ms. Nelson served from 2014 to 2019 as the Executive Director of Reentry and Special Counselor for Criminal Justice Initiatives in New York, where she helped deliver comprehensive bail reform in 2019. Ms. Jillian Snyder is the Director, Criminal Justice and Civil Liberties at the R Street Institute. She is also a lecturer at John Jay College of Criminal Justice and a retired officer from the New York City Police Department. Ms. Snyder also teaches as an adjunct lecturer at John Jay College of Criminal Justice in the Department of Law, Police Science, and Criminal Justice. Mr. John Malcolm is the Vice President for the Institute for Constitutional Government, Director at the Meese Center for Legal and Judicial Studies, and Ed Gilbertson and Sherry Lindbergh Gilbertson, Senior Legal Fellow, Institute for Constitutional Government at the Heritage Foundation. He brings a wealth of legal expertise in both the public and private sectors. Malcolm is past chairman of the Criminal Law Practice Group of the Federalist Society and serves on the Board of Directors of the Legal Services. We welcome all of our distinguished witnesses and thank them for participating in today's hearing. I'll begin by swearing in the witnesses. I will ask that our witnesses in person please rise and raise your right hand. I ask that those that are remote witnesses please turn on their audio. Make sure that I can see your face and your raised right hand while I administer the oath. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and beliefs, so help you God? I need to hear you audibly.
I do.
I do.
Thank you. Let the record show the witnesses answered in the affirmative. You may be seated. Thank you. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there is a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. For our witnesses appearing virtually, there is a timer on your screen to help you keep track of time. Ms. Barco, you may begin, and you are virtual. Thank you very much, and welcome again.
Thank you, Chairwoman Jackson Lee, Chairman Nadler, Ranking Member Jordan, Ranking Member Biggs, and distinguished members of the subcommittee. Thank you so much for inviting me to testify on the important topic of sentencing reform. The United States leads the world in incarceration, and its harsh sentencing policies have separated families, destroyed communities, and produced gross racial disparities. But the biggest tragedy of all is that these policies haven't made us any safer. It's just the opposite. Our severe and punitive practices have increased the risk of crime. Now, the conventional wisdom for decades has been that the more severe the punishment, the greater the crime fighting benefits. And while that view might be common, it's actually mistaken. In fact, we have a great deal of evidence showing that excessively punitive practices cause more crimes than they prevent. So consider long sentences. When we give out disproportionate sentences, they undermine public confidence in criminal laws, and that in turn leads to reduced compliance with laws. People stop reporting crimes and cooperating with law enforcement, and that makes it harder to detect and solve crimes. Long sentences also undermine public safety because they make it that much harder for people to adjust when they're released from prison. 95% of all people who are incarcerated return to free society, and we should want their reentry to be successful. But the longer they stay in prison, the harder that is. It's no wonder researchers find evidence that long sentences increase the risk of crime when people get out, even when you control for their underlying crime and criminal record. For example, a study from Texas found that after a certain point, each additional year of incarceration caused an increased risk of recidivism between 4 and 7%. Now, some might say, even if these sentences aren't deterring, at least they're incapacitating people from committing crimes outside the prison walls. But here too, reality is much more complicated than this gut instinct. For starters, most people age out of most criminal behaviors, even without any governmental intervention. And besides aging out of crime, people stop committing crimes for other reasons. They address underlying substance abuse problems. They get mental health treatment or employment. So keeping people behind bars for decades doesn't bring incapacitation benefits after a certain point for so many people because there's nothing to incapacitate. In addition, because most people eventually rejoin society, we need to weigh whatever incapacitation benefit we're getting against that increased risk of recidivism from longer terms of incarceration. And all too often, the risks outweigh the benefits precisely because the person would have stopped committing crimes in any case, and time away from society has made it so much harder for them when they're released to stay on a law-abiding path. So a comprehensive analysis of this issue, looking at all the studies, has concluded incarceration certainly reduces crime outside prison as long as it lasts, but it appears to cause more crime later. So unfortunately, the flawed premise that we need to be as harsh as possible underlies so many of our laws and practices. We're spending a fortune on punitive practices that don't work to make us safer, and they tend to make things worse. So whether your concern is fiscal conservatism, racial justice, public safety, or a fundamental respect for human dignity, all roads point to the same solutions. We need to roll back the harsh policies of the past 4 decades. Now, I'm just going to briefly offer a checklist of what those some reforms should look like. It's not meant to be exhaustive, but it does give you a guidepost. It means eliminating mandatory minimums, which have failed in all their policy objectives. It means allowing the Sentencing Commission to make decisions based on evidence instead of congressional directives that aren't based on any evidence or data. It means making retroactive relief available for anyone who's punished under a law that has since been changed to reduce sentences, something we've seen works because the Sentencing Commission has that authority and has retroactively reduced sentences to great effect. There should be second look mechanisms for individuals, either through parole or allowing a judge to make adjustments because circumstances and people change. We need to eliminate the harsh collateral consequences that are attached to convictions that make it harder for people to re-enter, and we need to limit the use of pretrial detention. Again, not an exhaustive list, but it gives you an idea. There aren't many areas left in public life that offer this kind of win-win, but criminal law is one of them. It's why it's been the rare space of bipartisanship, even in these polarizing times. And it's my hope that it'll continue to be a place where we can all come together to make us all better off. Thank you for allowing me to testify and share my thoughts, and I'd be happy to answer any questions you may have.
Gentlelady's time has expired. Thank you very much. And I yield now to Mr. Underwood for 5 minutes.
I first want to thank Chairwoman Jackson Lee, Chairman Naylor, Ranking Member Biggs, and members of this committee for holding this hearing today and for sharing this space to hear stories about the impact that the war on drugs has had on people like me and families like mine. My name is William Underwood, and I'm a senior fellow with the Sentencing Project's Campaign to End Life Imprisonment. 50 years ago today, President Nixon declared the war on drugs. I was a 17-year-old father at the time. There was fast money to be made, and I was not going to allow my son to grow up in a world of hunger and pain that I had. Just like any other war, this one has eviscerated entire generations in communities like the one where I grew up in Harlem. While it's called a war on drugs, its disparate impact over the decades has made clear that this is actually a war on the poor, a war on inner city youth, and a war on Black people and other communities of color. I witnessed that reality every day of my 33 years of incarceration after being sentenced to life without the possibility of parole and a concurrent 20-year sentence for leading a violent drug operation during the 1970s and early 80s in New York City. From the beginning of my incarceration, I was surrounded by other men of color serving lifelong and other extreme sentences, including for drug offenses, handed down under a mandatory minimum sentencing structure that never accounts for an individual's growth, rehabilitation, and transformation while incarcerated. This experience wasn't unique to the prisons in which I served. In fact, 1 in every 7 people in U.S. prisons are serving a life sentence or virtual life sentence of at least 50 years. Nearly 4,000 of those people are serving life sentences for drug-related offense, 38% of whom are in the federal prison system in which I served. Men like Tony Lewis Sr., Wayne Prey, Todd Vassell, Thomas Jackson, Stephen Peterson, Darrell Riley, Spencer Bowles, and Stephen Brown. I was extremely lucky that I was granted compassionate release in January at 67 years old. Judge Sidney H. Stein found my sentence reflected the seriousness of my criminal behavior when I was convicted 33 years ago, but its extremeness did not account for the person I am today. Judge Stein's order stated, in light of Underwood's exemplary record over the last 3 decades, his consequential mentorship of young men and contribution to a culture of responsibility in federal prison, and his commendable efforts in raising and supporting his children and grandchildren from behind bars, the court finds that Underwood's good deeds exceed the bounds of what we consider rehabilitation and amount to extraordinary and compelling reasons meriting a sentence reduction. I was not the exception in prison. Many others like me remain and will take their last breaths there. Like me, those men have also spent decades having to get to know their children through 15-minute phone calls. Like me, they have had to see their grandchildren grow up through nothing but photographs. I'm very fortunate to have 4 successful children who have always fought for me, supported me, and helped me maintain a piece of the music publishing rights that I owned before my incarceration. But it comes as no surprise that the lack of preparation provided in prisons leads so many young people returning to their communities to end up on the streets or back in prison. There's got to be a better way. Regardless of their intended purpose, mandatory minimums go against the rule of law by perpetuating disproportionate prison sentences and aggravating racial disparities in the criminal justice system. A wealth of research shows that prosecutors bring charges carrying a mandatory minimum sentence against Black defendants at higher rates than white defendants. Research also illustrates that people age out of criminal conduct as they get older. Life sentences do nothing to promote public safety and only perpetuate cycles of poverty and trauma. Extreme sentences ignore people's capacity for change as human beings. We are capable of painful yet transformative self-reflection, maturity, and growth, and to deny a person this opportunity is to deny them their humanity. There's no reason to wait decades into a person's sentence to begin evaluating their growth and readiness to rejoin their families and communities. By granting a second look after 10 years and releasing those who have proven they have worked for it, deserve it, and are ready for it, we can reunite families and free up resources in the justice system to prepare those inside for a successful release. So I come before you, a reformed man, an atoned man, with the hope that you will hear my words, hear the honesty and commitment in my voice, and be moved to understand why each and every one of us, when given a chance, can be better than the worst thing we have ever done. We all deserve a second chance. Thank you.
Mr. Underwood, I'm going to take the liberty of saying thank you so very much for your powerful testimony.
Thank you.
We thank you for being here today. And I hope that we will all learn from, among others, your testimony, which is extremely important. Ms. Frederique, you're recognized now for 5 minutes.
Chairman Jackson. Chairman Jackson Lee, Ranking Member Biggs, and members of the committee, thank you for the opportunity to submit this statement upon the committee. I am the Executive Director of the Drug Policy Alliance, the nation's leading organization advancing drug policies that are grounded in science, compassion, health, and human rights. Today is not just the anniversary of a policy agenda around drugs. Today is also the anniversary of the calcification of this country's commitment to using punishment, surveillance, and imprisonment of people who disagree with those in power. Today I sit here testifying that our country's principles of freedom, autonomy, liberty, and joy are for all and not for some. A day after our Congress has made Juneteenth a federal holiday, I'm sitting here today to say that not all of us are free, and that there is much work to do by this body to make freedom realized. For more than 50 years, the United States has adopted and expanded punitive policies toward the possession, use, and distribution of drugs, enacting increasingly harsh sentencing laws that lead to mass incarceration and mass criminalization while ignoring the destructive impacts of those laws. The sentencing laws at the heart of that deeply flawed strategy have led to mass incarceration, fractured families and communities, interrupted educational and vocational progress, blocked opportunities to contribute to society, and killed American dreams. The human and fiscal impacts of this destructive policy are staggering. Every month, approximately 1,600 people on average are sentenced for drug offenses in federal court, and over 1,000 people are sent back to prison for violations of supervised release or parole related to drugs. Drug convictions still account for the incarceration of almost 500,000 people. 1 in 5 people currently incarcerated in the US are locked up for a drug offense, while over 750,000 people, or 25% of all people under community supervision, are on probation or parole for drug law violation. Although rates of drug use and sales are similar across racial lines, Black and Latinx people are far more likely to be criminalized than white people. Every year, the federal government spends $35 billion on law enforcement, federal courts, forensic scientists, community supervision, and drug testing. What if we had invested that much money in education, health, and employment opportunities for our communities? And yet the drug war has achieved no meaningful reduction in drug supply or prices. Instead, it has exacerbated the dangers of illicit markets. Long prison sentences have done nothing to stem the rate of drug overdoses, but instead have prevented the implementation of robust harm reduction systems and driven people who need and want help further from the public health resources. In fact, overdoses have reached an all-time high. Nearly 850,000 people have died from a drug overdose since 1999. More than 70,000 died in 2019 and almost 90K in 2020. For Breonna Taylor, Carlos Ingram Lopez, Andrea Circlebear, and for my dear friend Alexis's son, Jeff, and for my aunt and uncle's son, Stanley Frederick, who we buried last week, Congress must take bold steps to refocus the federal strategy, pivoting from the central premise that drug use is something that should be punished. Instead, the federal approach should be health-focused, evidence-based, and respectful of self-determination. Congress should move quickly to reduce sentences of incarceration for all drug offenses, particularly those related to possession and the distribution of personal use quantities of controlled substances. Additionally, it should fully repeal mandatory minimum sentences and vastly broaden the safety valve provisions, enact substantial reforms to supervised release to limit drug-related technical violations and reincarceration, revisit harsh drug enhancements like the distribution resulting in death statute that allows for excessive and arbitrary sentences while discouraging others close to a person experiencing overdose from seeking medical help. Ensure that drug possession is no longer the cause of mandatory detention and deportation of non-citizens or otherwise lead to immigration consequences, tearing apart families. Reject efforts to further criminalize fentanyl and its analogs, and instead embrace a public health approach to drug use. Madam Chair, this must be a turning point. For 50 years, the drug war has filled our prisons and derailed individual lives and disrupted families and communities. The fiscal and human costs are incalculable. We must start enacting evidence-based policies rather than those based on arbitrary punishments and have no demonstrated benefit in keeping people safe. Thank you for the opportunity to submit testimony. I look forward to working with you all to create a world where we no longer waste money, destroy lives, decimate communities, but rather support people in getting services, support, and treatment they need to thrive.
Thank you for your testimony. And now we yield to Ms. Nelson for her testimony. Members, at the conclusion of Ms. Nelson's testimony, we will recess for votes. We thank the witnesses for their indulgence. We will continue after votes on the floor of the House. Ms. Nelson, you're recognized.
Good morning. Thank you, Chair Jackson Lee, Ranking Member Biggs, and members of the subcommittee. I'm Marta Nelson, Director of Government Strategy at the Vera Institute of Justice, a 60-year-old organization that provides data, evidence, and solutions to fight mass incarceration and to transform the criminal, legal, and immigration systems until they are fair for all. I have worked for over 25 years on efforts to stem the effects of our country's addiction to punishment, and I am delighted to offer remarks on behalf of Vera on this long overdue topic of sentencing reform. This hearing notes the 50th anniversary of the war on drugs, but the early 70s also marked the start of mass incarceration and extreme sentences. We have as many people, over 200,000 to be exact, serving life sentences today as we had total in prison in 1970. Black and Latinx people bear the brunt of this policy. They comprise 32% of our country's population, yet make up 56% of the prison population. It doesn't have to be like this. If we incarcerated our citizens at the same rate as the rest of the world, we would have 1/6 of the people we do in prison, instead of about 360,000 instead of over 2 million. It's not that people in other countries do not engage in violent or harmful behavior and are not convicted of crimes. They do, and they are. The difference is in how our systems respond. In stark contrast to the United States criminal legal system, in Europe, the default, even after a felony conviction, is a community-based sanction. To change where we are, we need to take bold steps. We suggest 7 legislative changes that, taken together, could reduce the federal prison population by 80%, according to preliminary Vera modeling. They are removing sentencing enhancements based on prior conviction records, creating a maximum incarcerative sentence of 20 years for the most serious crimes, significantly expanding opportunities to earn good time off of sentences, abolishing mandatory minimums, allowing people convicted of all crimes the opportunity for community-based sentences, creating second-look resentencing options, and requiring racial impact statements before criminalizing any new behavior and enhancing punishments to already criminalized behavior. These reforms share 3 attributes. First, they promote actual safety, not performative safety. One influential meta-analysis of studies on deterrence concludes it is clear that lengthy prison sentences cannot be justified on a deterrence-based crime prevention basis. Instead, community-based programming, even for people who've been charged with violent crimes, has been shown to reduce future unlawful conduct. Indeed, many of the rehabilitative innovations of the last 30 years were pioneered in the community. There may be a need to incapacitate those few people who truly cannot walk safely amongst us, but that is a small minority of the people behind bars now. Second, these repairs repair harm. By a margin of 3 to 1, survivors of crime prefer holding people accountable through more proactive measures like mental health treatment, drug treatment, restorative justice, or community service rather than prison sentences. This is because prison sentences are not proactive, they are reactive. At bottom, they don't require the person to do anything other than to be removed from society. Sentencing could instead create a community-based process for the person to acknowledge and address the harm they've caused. Third, these reforms address racial justice. Our current excessive sentences grow from the harsh on crime policies of the 70s to the 90s, following the gains of the civil rights era, amidst a racialized panic over crime and drugs. Recognizing this origin, jurisdictions must assume racial biases will continue to impact every part of the criminal legal system and should sentence with a light touch, privileging liberty as much as possible. Finally, urging these reforms now, when homicide rates across the country have increased regardless of criminal legal policies, and when gun violence has also increased, may seem challenging to those who think that this is the time to be tough on crime. That would be a serious mistake. Again, increasing jail and prison sentences is a poor crime deterrence strategy. In addition to approving crime clearance rates, which research shows can deter crime, jurisdictions should invest heavily in proven solutions to gun violence, such as violence interruption, hospital-based interventions, and focused deterrence. The best crime prevention solution of all is to invest in the services, resources, and supports that help communities flourish and thrive, especially after the devastation of the pandemic. Thank you.
Your time has expired. Again, members, we are now in recess until the completion of the vote on the floor. Witnesses, thank you very much for both your testimony and those that we will hear when we return, and thank you for your indulgence. The hearing is now in recess. We are resuming the hearing on undoing the damage of the war on drugs, a renewal call for sentencing reform before the Subcommittee on Crime, Terrorism, Homeland Security of the Committee on the Judiciary. We're pleased now to yield 5 minutes to Ms. Snyder.
Good morning, Chairwoman Jackson Lee, Ranking Member Biggs, and members of the committee. Thank you for the invitation to testify today. My name is Jillian Snyder, and I'm the Director of Criminal Justice and Civil Liberties Policy at the R Street Institute, which is a nonprofit, nonpartisan public policy research organization. Our mission is to engage in policy research and outreach to promote free markets and limited effective government in many areas, including criminal justice reform, and that is why today's hearing is of special interest to us. In addition to my current role, I'm also a lecturer at John Jay College of Criminal Justice and a retired New York City police officer. Today, I'm here to speak to you about the critical nature of bipartisan support for the Equal Act. Although the aggressive law enforcement approach to the crack epidemic of the 1980s was initially designed to decrease the spread of drug-related disease and death and to combat organized crime, we now know that it instead led to an over-reliance on arrests, incarceration, and sentencing disparities, all of which have had a disproportionate impact on Black and Latinx men in urban communities. Indeed, for far too long now, the United States has relied on a system of over-criminalization that overuses and at times outright misuses criminal law to address societal problems that are more effectively handled through civil channels or by other interventions. Recent data shows our nation's incarcerated population boasts approximately 2.3 million individuals, 430,000 of which were in prison for drug offenses. In fact, an overwhelming 92% of individuals in federal prison have a drug offense as their most serious criminal charge. This is largely because lawmakers of the past assumed that the use or sale of drugs had a causal effect on violence, and by this logic, stricter penalties on drug-related offenses would deter future criminal activity. However, subsequent data indicates that this is not the case. On the contrary, increased incarceration has had only a small impact on crime rates, and most of the benefits relate only to property crimes. Moreover, although drug abuse may cause income-generating crimes like burglary and larceny, it is not directly causal of violent crime. In fact, a recent cross-sectional analysis of more than 7,000 prisoners indicates that binge consumption of alcohol is more closely correlated to violent crime than the use of cocaine. Currently, approximately 35% of federal drug offenders are considered Category 1 by the U.S. Sentencing Commission, which means they have no previous terms of imprisonment or extremely minimal criminal records. Additionally, of individuals with linked U.S. Sentencing Commission reports, less than 5% have a violent crime as their most serious offense, and less than 25% of federally sentenced drug offenders possessed an illegal firearm as part of their arresting offense. Recognizing our past mistakes, several states have reclassified and downgraded drug offenses and increased the quantity thresholds necessary to raise offenses to the felony level. In many states, there is no difference in statutory penalties between powder cocaine and crack cocaine. In New York, for example, the two are treated the same, recognized in the state penal law as controlled substances. Over the course of my policing career, I have seen how these positive changes at the state level are too often nullified when the federal government asserts jurisdiction over what is clearly a state matter. A decisive 67% of Americans who self-identify as Republicans, Democrats, and Independents believe that government should focus more on providing treatment for illegal drug users than prosecuting them. What's more, national law enforcement organizations such as the Law Enforcement Action Partnership also recognize that while drugs are potentially addictive and cause self-harm, drug abuse is a public health problem that requires a more nuanced approach. The United States relies on the principles of justice and equality for all, but the past 50 years have clearly demonstrated that, in the case of narcotics enforcement, the law has not been equally or justly applied. Rather, the war on drugs arrested and sentenced tens of thousands of individuals, ultimately for an often victimless, though socially intolerable behavior, and the no-knock effects were profound. The disruption of families, the loss of housing and potential employment, the inexcusable disparity based all too often on race, ethnicity, or financial status rather than public safety concerns. Luckily, the Equal Act represents a golden and popular opportunity to reform sentencing to reduce these disparities and to focus on a more humane rehabilitative approach, instead of a largely failed punitive one. That is why support for the Equal Act cannot be mired in partisan politics. Lives are at stake. Instead, bipartisan support must continue as you strive to achieve a meaningful solution to this ongoing crisis. Thank you to the subcommittee for holding this hearing. If I could be of any assistance to members of the committee, please feel free to contact me or my colleagues at the Art Street Institute. Thank you.
We thank you very much for your testimony, and now we'll yield 5 minutes to Ms. Givens for her testimony.
Good morning again. Thank you, Committee Chairwoman Jackson Lee, and Committee Chairman Nadler, and Ranking Member Biggs. I am a federal public defender from the Eastern District of North Carolina. I've been proud to serve as a public defender for 16 years in 3 jurisdictions, both the West Coast and the East Coast. I agree with so many of the recommendations already shared by our esteemed panel member of witnesses. Most importantly, abolishing the mandatory minimum. As I sit here today, I can't help but think about who is on my caseload. And I want the committee to remember who our policies affect. As I sit here today, I have 48% of the people on my caseload are eligible for mandatory minimums. Many of these young people are between the ages of 18 to 26. That is entirely too young during developing adolescence to throw these young people into our prison system for time periods that equal 5 to 15 years. We are erasing entire phases of life for a whole generation. I'm asking the committee to remember that the laws that you pass impact real lives. Some of those lives that I see on my caseload include a whole bunch of young people who fell through the prison, who landed at the prison system by falling through the education system. And let us not forget also a whole bunch of our prisoners are people who grew up in the foster care system. I have represented a young couple who was expecting preemies, and I could not get the young man out. He missed the birth of his children. This one family he ever knew, he was removed from for a mandatory minimum period. I'm asking this committee to really consider some specific areas of the mandatory minimum and the impact it has. That is the recidivist statute of 851, the drug recidivist statute, and the 924C, which is a combination of drugs plus a gun or drugs plus a violent crime. These are some of the most popular convictions that we see in our nation, and they also come with mandatory minimums. Simply making an impact on this area could seriously reduce and have a positive impact on reducing mass incarceration. I submitted in my testimony a young woman who it represents something we often see, which is young people in a car with a gun and drugs, ending up with a 924C and a mandatory minimum of 5 years. This was a young student athlete who was not the driver, she was a passenger, and she is serving a sentence today for at least 70 months. I also want to touch on something that Ranking Member Briggs alluded to, which is the over-federalization of local crime. It results in task force like Project Safe Neighborhoods that actually does not accomplish the goals that it intended. We have got to take a close look at the over-federalizing of local crime and bring it back to the place that it belongs. The impact of these task force usually mean over-surveilling and over-policing communities of color. That is Black and brown individuals. And we hide behind pretty names like Project Safe Neighborhood when this does not make our neighborhoods safer. Long sentences do not ensure public safety. And we've got to sentence like we believe it. We've got to sentence like supported by data. Last but not least, I want to ask the committee to really think about our youth. This 18 to 26-year-old group, we need to reclaim them. We need to recover them and remove them from the federal prison system. They should not be subject to mandatory minimums under 851 or 924. And last, we should recenter drug misuse as the public health crisis it is. Drug addiction and mental illness is a public health crisis, and the criminal justice system is so closely linked. We've got to address it as a public health crisis. I look forward to working with you, accepting your questions, and ask the committee to take action. The war on drugs was a failure, and we need to leave it where it was. Thank you.
Thank you for your testimony. And Mr. Malcolm, you are now recognized for 5 minutes. We owe you one.
There we go. Distinguished members of Congress, I am the Vice President of the Institute for Constitutional Government and the Director of the Meese Center for Legal and Judicial Studies at the Heritage Foundation. Although I spent much of my career as a federal prosecutor, I recognize that our criminal justice system is far from perfect, and that when it comes to sentences in drug cases, the pendulum can swing too far. Based on recent changes in state laws, it also seems clear that a lot of people believe that we should recalibrate how we tackle the drug problem that continues to plague our country. Sentencing reform is part of that ongoing discussion. Let me offer a few thoughts on some of the proposals that you are considering. Regarding the First Step Implementation Act, I endorse any effort to ensure that the First Step Act is fully implemented. But while there are many parts of this bill that I support, there are some that give me pause. So the First Step Act modestly reduced mandatory minimum penalties for certain repeat drug offenders, but only on a prospective basis. In addition to making these changes retroactive, the First Step Implementation Act would expand eligibility to those who commit a serious violent felony. I question whether this expansion makes sense at a time when we have experienced a dramatic spike in violent crime, although I recognize that eligibility for sentencing reconsideration does not mean that an offender will automatically, or even very often, get his sentence reduced. The act would also enable a judge to take a second look at the sentence imposed on a juvenile offender who has served a minimum of 20 years. I have similar concerns with respect to juvenile offenders who commit unspeakably violent crimes, but I recognize that such offenders would not be eligible for relief until they had spent over half their lives behind bars. The act would also expand the current safety valve to allow a judge to impose a sentence below a mandatory minimum if the judge determines that a defendant's criminal record substantially overrepresents the seriousness of the defendant's criminal history or the likelihood that the defendant will commit other crimes. While I believe that the safety valve was too stringent prior to the passage of the First Step Act, I'm a bit uncomfortable with expanding the safety valve to recidivists who have more than 4 criminal history points based on such inherently subjective factors or criteria. The Equal Act would eliminate altogether the current 18-to-1 disparity between crack cocaine and powder cocaine offenders when it comes to imposing mandatory minimum penalties, and it would make this change retroactive. There is some evidence that suggests that crack is more addictive than powder cocaine based on the different ways that the two drugs are ingested and the fact that crack is much cheaper. The vast majority of states, though, do not treat crack cocaine any differently from powder cocaine. Additionally, regardless of the intent behind these laws, it is clear that the greatest impact, both in terms of extremely long sentences handed down to offenders and the devastation that drugs have wrought, has been felt in communities of color. While I don't have a settled view on whether it makes sense to completely eliminate the differential, the current 18-to-1 disparity certainly does strike me as excessive. Both the First Step Implementation Act and the Equal Act have provisions that would apply retroactively. While I respect the legitimate concerns expressed by many about applying changes in sentencing laws retroactively, I believe that if society has made a judgment that certain sentences are unduly harsh, then it must believe that those sentences were too harsh and unjust when they were originally imposed. In my opinion, enabling a judge to reconsider a sentence is a smaller price to pay than allowing offenders to languish in prison for longer than society now deems as just. In conclusion, let me say that the work you're doing will have a dramatic impact on both the victims and perpetrators of crime and their families. It will also shape how people view our criminal justice system in terms of its effectiveness and its fairness. Over the years, I have dealt with many people who approach these issues from different ideological perspectives. Some believe the system should be changed because of systemic racism or mass incarceration. Others believe we do not place enough emphasis on rehabilitation and redemption. While I don't always agree with them, I acknowledge that the people who espouse these views believe them passionately and sincerely. In speaking to these thought leaders, I have often been struck at how often people agree about what ought to be done, even if they disagree about why those measures are warranted. Sadly, too often, nothing gets done, either because people get caught up on the why rather than focusing on the what, or because they insist on an all-or-nothing approach with respect to the proposals they support. As you deliberate, I would urge you to focus on your areas of agreement and not let the perfect be the enemy of the good. I thank you for inviting me here to testify today, and I would be happy to answer any questions you might have.
Thank you. We thank all of the witnesses for their testimony. This is a crucial crisis in our nation, and all of you are contributing to our discussion. We will now proceed under the 5-minute rule with questions. I'll begin by recognizing myself for 5 minutes, but just for a moment, I'll ask if the ranking member of the full committee desires at this time to have his 5 minute. Mr. Jordan.
Madam Chair, I think Mr. Jordan has left, so I think he'll waive that for now. If he comes back, I'll let you know.
We'll extend that courtesy. Thank you so very much. Ms. Barkow, for decades, Congress passed extremely harsh laws that undermined public safety, created racial disparities, chaos in the federal courts. Congress' approach to crack cocaine and the entire framework of mandatory minimum sentences is one example of how the failed war on drugs destroyed communities for generations. Those of us who live in certain communities are always reminded of neighbors, friends, extended family members who were just simply standing on a street corner and were caught with conspiracy charges and drugs and got 25 years. They were like Mr. Underwood, 17, 18, 19, 20. What mistakes did Congress make in its approach to punishment, and what are the steps to developing laws that are rooted in sound policies? Barkow?
Thank you, Chairwoman. Madam Chairwoman, I would say there were several mistakes that I'd like to highlight. And the first one was that the way to solve issues of drug addiction or use or sale is by long sentences, which, as I said in my initial statement, the evidence just doesn't bear that out. When you arrest and incarcerate one person, they're easily replaced by someone else. So those long sentences really did nothing to address the underlying problems of drug abuse. In addition, as you mentioned, it ended up that using those really harsh sentences destroyed families, neighborhoods, communities, lives, with no public safety benefit attached to them at all. And, you know, we really miss out on the valuable contributions of these people locking them away. And when Congress made these decisions, you know, they did so in an environment that was essentially data and evidence free. It was all based on intuition and a kind of gut instinct that we'll just lock this problem away. And unfortunately, Congress did it at a time when it had also established an expert agency, the Sentencing Commission, which was supposed to help Congress address sentencing policy. But before even giving the commission a chance, it went and passed sweeping mandatory minimums, the Armed Career Criminal Act, a whole bunch of laws that had no evidentiary basis for them other than this underlying premise of let's be as harsh as possible. And, you know, I think that harsh reality fell disproportionately on young people and on communities of color. And what we know about that is those young people would have aged out of their criminal behaviors, but they are serving sentences far beyond what they would have ever needed to do that. So, I would just urge all of you to look at all the evidence we now have, to see that these sentences are really grossly excessive. And just the last point I'll make in that regard, you can have great confidence that you can reduce sentences because we've seen it. We've seen it done at the federal level. The Sentencing Commission reduced all federal drug sentences. On average, by a couple of years. And those recidivism rates stayed low. They were no different than people who served their full sentences. We've seen state after state dramatically cut sentences. They've reduced their incarceration rates and they've reduced crime at the same time. So we have the evidence that reducing sentences works. And I would just urge Congress to take that new path.
Thank you very much. Let me, Mr. Underwood, again, thank you for your powerful testimony and the work of your daughter, who is also in this work. You were sentenced to life without parole. Might you tell us how old you were? But what do you think is a more effective approach than extreme penalties like life a sentence? And what would have been the appropriate sentence for you in light of what you were doing? You're a father, and there is a basis of rehabilitation in the prison concept. Mr. Underwood. Your mic, please, sir. Your mic.
Sorry. Yes, Chairwoman. Yes, ma'am. 10 years would have been an appropriate sentence. I say 10 years because 3,650 days, 24 hours a day. You have, when you're doing time in prison, you have an opportunity to commit to either you want to go down that road and stay on that road and go down the road of perdition, or you want to go down the road to redemption. You have a choice yourself to make whether you want to play chess, play cards, play basketball, play all these other things, but in a real sense that day in and day out, you have to begin to deal with you're doing time. And that doesn't change, and that you destroyed some families, you destroyed your family, you destroyed your community bonds, and you have to be an individual that wants to commit to bettering themselves and educating themselves. And the system is, while we do have law libraries or libraries per se with educational tools in them, they are not adequately staffed to prepare an individual for reentry. I've seen that over and over, especially with young people. They don't have, we live in we have typewriters, what do you call those? But it's just it's a skeleton. Yes. It's basically, you can email people, but you can't really do, they have the vehicles there, they have the tools there to put a flash drive in full of educational, access for young men, young women, but they don't do that. They use those for GED programs, and it's really a joke. Everybody and at least on my side knew that was a joke. You come into a room there's like 50 computers potentially set up to teach young people how to code, to do something, to give them some incentive to want to learn how to do things, and they're just in there, just skeletons, and it's a waste of money. And they basically impart to people, you come in, if you're on a list to go take your GED, well, if you don't go to the GED class, you get a shot. That's a write-up.
Thank you.
But if you do go, you get this incentive to. They give you $25. So so what I'm saying is that the individual himself has to aspire to really want to change themselves. And you come across a lot of young kids that really do, but they don't have the tools themselves, and they rely on elder inmates or people with education in prison, basically, to help them, reach their goals.
Thank you very much, Mr. Nelson. My time has expired. I had additional questions, but I will yield now to the gentleman from Ohio, Mr. Shabbat. Thank you very much.
Thank you, Madam Chairwoman. Thank you very much. I want to start out by thanking all the witnesses for being here, both in person and by video. A little over a year ago, in the wake of the death of George Floyd, protesters in cities and communities all over the country proclaimed, at least some of them, that because he and others, particularly minorities, have been killed by police officers, that police departments needed to be defunded, even in some cases dismantled. We then saw a number of cities do just that, cutting billions of dollars from police resources across the country. For example, here in our nation's capital, in Washington, D.C., $15 million was cut out of their budget. Baltimore, not far from here, they cut 20. L.A., $150 million cut. And in the Big Apple, New York City, $1 billion was cut from the police budget. Well, as they say, you reap what you sow. Here in Washington, D.C., 43% increase in homicides this year compared to this point last year. Baltimore's violent crime went up, so they decided to add back $27 million for the police. L.A. experienced a 12% increase in homicides, so its mayor proposed adding back $50 million to the $150 million that they'd cut. And in New York City, they experienced a 97% increase in shootings and a 45% increase in their homicides. Last year in the city that I represent, Cincinnati, most of it is in my district, they experienced the deadliest year on record with 94 homicides when compared with some other cities. That may not sound like a lot, but that's the most in the city's history, and an increase in violent crimes in the months of civil unrest that followed George Floyd's death. Ms. Snyder and Mr. Malcolm, I'd like to direct this to you folks, if I could. Could you comment on the impact that the defunding the police and the over-the-top criticism of law enforcement by many in the media and by some of the protesters, again, not all, but many that have criticized the police, and the threat, and this threat came from Congress to eliminate qualified immunity, which would have meant that police officers could be sued in their personal capacity. So your house, your savings, your kids' college funds, if you made a mistake or were accused of it, even if you hadn't done anything wrong, you still have tremendous attorney's fees and that sort of thing. But to take away qualified immunity, so all of this, do you have an opinion as to what impact that has had on the recruitment of police officers across the nation? And do you have an opinion as to whether that whole emphasis against the police has had an impact on the homicides and the rates going up in this country? The defunding, is there a relationship there? I'd ask either one to take that, or both.
Ms. Snyder has said that I can go first. I think that the defund the police movement is insane, and there is no question that there are problematic relations between police officers and the communities that they serve. Both of them suffer as a result of that, and while there are certainly issues that need to be worked through, I think one needs to keep in mind that the far bigger problem is the violence happening primarily in our inner cities that are under-policed with respect to things like qualified immunity. Certainly, the defund the police movement, the hostility to the police has got to have an impact on recruitment. It probably also leads to an expansion of what's been referred to as the Ferguson effect. And while I am not a big fan of the many of the court interpretations involving qualified immunity, I fear that completely doing away with qualified immunity would have a very, very bad impact in terms of recruitment for police officers at a time when they are most needed, particularly among African Americans and Hispanics in terms of recruiting qualified officers from those communities.
And Ms. Snyder? You're a former New York police officer yourself, if I'm not mistaken. Is that right?
Yes, I am. So I'm going to say I completely agree with Mr. Malcolm's perspective. I do not at all support the rhetoric around defunding the police. I could get on board with maybe changing the verb to diverting funding somewhat to programs that will inevitably lead to less reliance on policing. In terms of morale, the word defund, it demoralizes police officers. It makes them feel like the public doesn't appreciate what they're there doing every single day. And obviously their goal is to protect and to serve their community members. In terms of qualified immunity, I think what we need to do is ensure that police officers know that as long as they do their work within the scope, within the law, and they still are entitled to an indemnification policy where they would not be subjected to liability if they were sued civilly. I think we need to put the parameters in effect like that to ensure that we don't lose the recruitment, because as you saw, New York City police officers, I think we lost about 15% in the last year or two. A lot of officers who are eligible for retirement are running to the pension section to retire. And I think that the defund the police movement is really encouraging people to want to leave the profession.
Thank you very much. My time's expired, Madam Chair. Yield back.
I thank the gentleman. I now yield to the gentlelady from Georgia, Ms. McMath, for 5 minutes.
Thank you, Madam Chair, and thank each and every one of you for your testimony today. We really, really appreciate you being here. Last March, so much of our society changed as we tried to reckon with, the danger of COVID-19. We re-examined many of our systems as we tried to keep our people safe, and including our criminal justice system, our prisons, and our jails. State and federal officials took many different approaches to doing this, and including using home confinement authority, expediting parole, and other methods of reevaluating where and for how long people would actually serve their sentences. Critically, officials wanted to make changes while maintaining public safety and also avoiding a rise in recidivism. The goal was to release individuals, and that was a decision that we ourselves were trying to make here in Congress, or to move them to home confinement or to protect their health and the health of those who work in prisons, while also not releasing anyone who might be posing a danger or risk to the public. And I'm going to ask each of you if you would chime in briefly, and anyone is free to answer this question, but can any of you speak to whether these goals were actually achieved and how we might study the effects of these different kinds of actions that were taken and what they can teach us about using home confinement for elderly individuals or for those who have health conditions? Mr. Underwood, you look like you might want to chime in.
Well, ma'am, the elderly, for the most part, are left defenseless in prison. I actually watched, well, I'm 67. So I watched men that were in their 50s actually, when this, first of all, when it hit, we immediately realized when we were locked down that, the televisions were off, and we just listened to NPR and whatever else other news we could garner, that, this thing is viral. I mean, it's airborne. It's going around the world because it's moving too fast, and it's just destroying too many lives. But I saw men that were sick from diabetes and whatever other ailments they had, and it really attacked them first, the most. And I could actually see them physically deteriorate, and they serve no purpose being in there around. There's really, I couldn't see anything that they were doing for them. So for them to especially when you have older men that are really, for the most part, their sentences are almost done. You know, they certainly don't want to come out into the world and commit any more crime. You know, but it's basically a service that you're doing to let them die at home or let them die in the free world as opposed to dying in jail, because you could actually really physically see people dying, deteriorating from.
Thank you for that, and I'm sorry that you had to witness that.
It was a traumatic thing to see.
Thank you. Anyone else?
So, Congressman, I'm a little unclear about your question. I gather you're asking about for elderly incarcerated individuals whether compassionate release and home confinement makes sense?
Well, I mean, really, actually, for any individuals that were confined during COVID at that time. I mean, well, the things that we tried to appropriate, the things that we tried to do to make sure that we were alleviating the possibility that some of those confined would actually, you know, end up having to stay incarcerated when they could actually have been released. We wanted to know any of the efforts that we tried to put forth or were done specifically within the prison system. Was any of that helpful?
Yeah, I don't know about the adequacy of those. Certainly the impetus behind making those changes for nonviolent offenders was important, not only in terms of protecting people who are being held involuntarily at the state because they've been incarcerated, but you know, there are people who work in those prisons who are, if they are exposed to a pandemic, which hopefully we are passing through, then bring that disease back to their loved ones in the community. And I think that people tried hard to make sure that prisons weren't a petri dish. Probably some succeeded better than others.
Thank you for that. Ms. Nelson, your testimony notes that we can reduce our prison populations by getting to the root of the causes of crime. So how can evidence-based violence intervention programs make our communities much safer?
Thanks for asking that, and I really appreciate that at the time that we're certainly hearing a lot about the crime rates that have been going up in the last year, which not coincidentally corresponds with a worldwide pandemic and is occurred independently of police being funded or defunded in some places. Police funding for the police went up, crime still went up. This is happening in every city, rural places, suburban places. So it is really independent of all that. And I think this is an opportunity for us to learn from what we did wrong in the 90s when crime was up as well, and to look at again at what actually stops people from shooting each other wherever they are. And there are a number of evidence-based solutions out there, including the Cure Violence intervention, which is a public health intervention for shooting, focused deterrence, which is a similar intervention but does include the participation of the police, hospital-based interventions in which folk go to victims of shootings who are in the hospital and try to stop retaliation from happening, and then again funding communities so that they have the resources and the bandwidth to be able to withstand this very stressful time that we're in. We have an opportunity now to jump on this, but we need to do that now before the violence continues to increase.
Thank you very much for your questioning. I now recognize the gentlelady from Pennsylvania, Ms. Dean, Representative Dean, for 5 minutes.
Thank you, Madam Chairwoman, and just an extraordinary day that you are all here, but also in celebration of Juneteenth. So congratulations on your hard-fought and well-deserved victory on that front for our country. I wanted to thank all of you for your compelling testimony about the area of the disproportionate, the crazy disparities, frankly, and the unsuccessful measures that we have put in place around sentencing. I thank you for speaking truth to the issues of addiction and the connection to the criminal justice system and the racist sentencing disparities that have cast a shadow over our country for the last 50 years, since the beginning of the so-called war on drugs. You eloquently, Mr. Underwood, said if it were a war on drugs, it would have been applied equally, and it never was. And you all eloquently talk about how it actually has been so unsuccessful. It hasn't made us any safer. My own family is touched by addiction, which I've spoken about publicly. My middle son, Harry, is 8 years, 7 months, and some days in long-term recovery from opioid addiction. And as he reports to me, he was a young man and a young father when he was falling deeply into addiction, stopped by the police many times. And as he says to us in our family, he was treated unfairly fair. Has no record, never spent time behind bars, was never separated from his infant daughter. He was treated unfairly fair. It is time we recognize that. So may I start with you, Ms. Federique? My sympathies to you and your family in loss that you have suffered. I want to talk about my support for the Equal Act, common sense legislation championed by our chair and colleague and friend, Representative Jeffries, that addresses the sentencing disparities between crack and cocaine. The bill notably provides for retroactivity. Would you kindly speak to the importance of retroactivity? And I'm thinking of a question that one of the testifiers said today: what will it say about us as a society if we change this and make it retroactive? What I think it says about us, if we do this, is that we as a society get a second chance to admit a mistake. What are your thoughts on retroactivity?
Thank you very much. We'll get that at some point. Thank you very much for that question. So the Equal Act introduced by Representative Jeffries is long overdue. And it is actually pretty incredible that we have people that are pushing for this moment. It is imperative that as we move forward and as we progress and put forward legislation that fixes the choices that we've made in the past, that those choices apply to the people that are languishing behind. What it says about our country is that everyone is worth the redemption, everyone is worth the progress, and that we are strong enough to recognize when we've done something wrong. We are strong enough to say this was a mistake, and we will atone and acknowledge that that has happened. I think this is a lesson we teach young people in preschool and in middle school and high school and in college and adults, and we say, you made a mistake, let's talk about it, let's talk through our feelings, and let's move forward. And I don't think anything impedes us as a nation from doing that for other people. We know the harm we've done with the disparate sentencing around crack cocaine, and it doesn't save us anything to not reverse those decisions for people that are inside. It makes us stronger, and it makes us stronger, but it also makes us truthful.
Exactly right. Well said. Thank you. Mr. Underwood, you said in your testimony there's got to be a better way, and I couldn't agree with you more. I had the chance to hear the Pope speak to prisoners at Kern-Fromhold Prison in Philadelphia when he visited a couple of years ago. And he said that Jesus comes to save us from the lie that says no one can change, the lie of thinking no one can change. I think you spoke to that. Could you tell us what we should be doing differently here in Congress to talk about those second chances and redemption?
There are so many men, Congresswoman Dean, that are, and women that are geniuses sitting behind bars, right, that have sat 10 years, 15 years, 20 years, 30 years. And to just interact with them and hear their stories, it's incredible. And these are people that could make a difference in their communities. These are people that have actually, they have atoned a long time ago, and they really don't want to be part of a system that any criminal organization or any kind of crime, they want to do the right thing. They just don't have the opportunity to do the right thing. And yeah, education is important. Education is vital. And in this new age where you have DSPs that dominate, and we all know digital service providers that dominate the landscape, you know, to have a prison industry that's basically they sit around and teach you how to make furniture and clothes, and that's not a productive you know, that's not a productive or adequate use of time for someone that's coming home to a world now that's dominated by technology. You know, we need we have so much to offer out here in the society to offer those that are on their way home that could make a difference in the world, that could do those jobs, that could help provide, pardon me, ma'am.
Thank you, Madam Chair. I yield back.
Gentlelady's time has expired. First of all, we all are very engaged in this testimony, and we've been allowing members to sort of spill over because it is such an important day, 50 years in your life, Mr. Underwood. It's testimony of how wrong the policy was, and I know that members know that this is a travel day, so we ask all of us. I have some questions at the end, but we will try to be consistent in our hearing. But these are important times and important stories, so members, I do want to have you on the record, and I thank you for your participation. The fact that the two gentlewomen from Georgia and Pennsylvania are so close together, we call them back to back. So we will now call Mr. Owens, and then members, we will call another Republican member, and then we'll come to the Democratic side. So we thank you for understanding equity and fairness. Mr. Owens, you have 5 minutes at this time. Thank you.
Thank you. Thank you, Chairwoman Jackson Lee, and Ranking Member Biggs for holding this hearing. Thank you to all the witnesses for your participation, and Mr. Underwood, thank you for your unique perspective. Really appreciate it. Sentencing reform is an issue that's near and dear to my heart. Several years ago, I had the opportunity to mentor a young college football player. He showed great promise and was a close friend to one of my children. Unfortunately, during his summer break, this young man, whose father had abandoned him and his mother, got involved with his uncle's drug trafficking operation. He was caught by authorities, and though it was his first offense, he was sentenced to prison. He was given a choice by a prosecutor who never lost and a public defender who never won. His plea offered 10 years if he did not fight the charge, or 15 if he did. He chose 10 years, and like tens of thousands of black men, he was ripped away from his family. His one-year-old son, like him, was also destined to be raised without a father. It will be 26 years, an entire generation, before the 2018 Trump criminal justice reform bill will be passed to begin to address this heartless mandatory sentencing of the 1994 Clinton-Biden crime bill. I'd like to make clear that the criminality, murder, destruction we're seeing in black communities across our country is not baked into our genes due to slavery 200 years ago. My upbringing in the segregated 50s and 60s proved what can happen to any community where there's a commitment to both mothers and fathers to their children. It was a proud black community of my youth that led our country to growth in the middle class, men matriculating from college, men committed to marriage, and percentage of entrepreneurs. So I'm pleased to participate in this hearing today, but I do think it's been misnamed. It should be the undoing of the damage of decades of terrible, progressive, anti-black policies. While sentencing reform is a very, very important issue that I support, we can't overstate the damage of decades of policies that have decimated urban black communities and minority communities. These policies include high minimum wage, a big benefit to increase wages of skilled union workers, but devastating to poor black youth attempting to get work experience. Welfare incentives that force young single mothers into government dependency and our young men into self-centered narcissism. Sadly, having babies and abandoning them over the decades have become acceptable, in many cases, unfortunately, even fashionable. Anti-marriage tax incentives that penalize men and women who commit to marriage. Anti-school choice, forcing poor children to remain in failing public schools, never learning to read, write, or think. The racist 1931 Davis-Bacon Act, which prioritized white federal unions over black entrepreneurs and small business owners. We are in a country that believes in second chances. Correcting overly harsh sentences for those who hurt the innocent in our communities should be important to all of us. As important is raising our young boys and girls in an environment that gives them a moral compass to give to their community instead of taking from it. It is imperative to raise them to understand that life obstacles are destined to come their way, but that they can overcome them as they learn to love God, country, family, respect of women, authority, and themselves. Ms. Snyder, According to the National Commission on COVID-19 and Criminal Justice, homicides and aggravated assaults rose significantly beginning in late May and June of 2020. After almost 30 years of a crime rate going down, why are we seeing this particular spike?
Thank you for that question, Congressman. What we fail to realize and what the media has been telling us is crime rates are surging, violent crime rates are so high, but they're still not as high as they were in the 80s and in the 90s. So yes, they have gone up, and to date, I can't tell you personally why crime rate has surged in the last year, but I'm going to say COVID-19 has been a very significant contributing factor. People were confined to their homes, people are losing economic resources, people don't have jobs. I'm going to say people probably got a little stir-crazy staying at home for 15 months, and those are all factors that could contribute to aggression, behavioral changes, and an increase in crime.
Do you have any other insights that you'd like to share in the last few seconds here on the current state of crime in the police force in our nation?
I'm sorry, can you?
Do you have anything else any other insights you'd like to share with us in terms of the current state of the crime that we're experiencing now or the police force in our nation?
None at this time.
Thank you. I'll give back my time.
The gentleman yields back. At this time, the chair recognizes Rep. Sparks.
Thank you, Madam Chair. As we know, criminal justice system is one of the core functions of the government to protect people's rights to life, liberty, and property. As a former state legislator, I believe there are a lot of things that states are doing, and sometimes it seems to me that there is a redundancy with federal crimes, and also it makes it more complicated. When the system gets complicated, it's kind of stuck against the people who don't have the money. And maybe that's why it's good to have some CPAs, not just attorneys in these committees, but it's definitely a learning curve for me, and I appreciate your input. It's important that punishment does fit the crime, and as one of my retired judges in my state told me, you know, Victoria, since we don't put people in jails for life, it's important that we rehabilitate and provide second chances to people. It's also important that we have a prevention. So I would like to get, and maybe Mr. Malcolm, you kind of discussed sentencing and the proposed bills. Do you have any thoughts also on the probation and supervised release mechanism within the federal system? As a federal prosecutor, give me some insights. Is there some things maybe could be improved there to provide more people opportunities? Because I think it's extremely important that we have this mechanism that get people back into really be valuable and productive members of the society.
You've raised a number of important points during your remarks just now. You've talked about the over-federalization of crime, where there are duplicative laws among federal and states, which dilutes accountability and also takes scarce federal resources and diverts them into matters that have traditionally been left to the states. You know, with respect to probation, people who are returning citizens after they have been incarcerated, I think it's important that you know, the scarce resources in terms of probation officers are focused on people who are most likely to recidivate. I think that we have a problem with too many technical violations returning people to prison too quickly. And then on the flip side, you'll get people who are repeatedly make violations and who are not dealt with in a timely manner, and before you know it, they have returned fully to a life of crime. Professor Barkow, actually, in her opening remarks, talked about a problem of collateral consequences that are imposed upon people who are released, that make it extremely difficult for them to reintegrate into society and become law-abiding members of society, you know, productive and being support to their family. So part of the probation parole process is also trying to make it easier by easing up on some of these collateral consequences to make it so that they have an opportunity to become productive members of society.
Any comments you have on supervised release?
Well, look, supervised release is, there's no problem having supervised release. I wouldn't necessarily say that it is a substitute for incarceration, but for certain nonviolent felons, depending on the circumstances of their offense, depending on the circumstances of their home life and their criminal history. So I know you're considering bills with respect to caretakers. Supervised release is certainly an option, as are alternative sentencing mechanisms. A lot of states have things like drug courts, veteran courts, mental health courts. These are all things that are worthy of exploration, and so long as the phrase evidence-based studies, so long as this is all evidence-based, I think these are all worthy of consideration and possible legislative changes.
Okay, thank you. I yield back. The gentlewoman yields back. The chair recognizes the gentlewoman from Pennsylvania, Representative Scanlon, for 5 minutes.
Thank you, Chairwoman Dean. The right to trial is established in our Constitution. However, we know that over the past few decades, plea bargains have largely replaced trials in our justice system. And when defendants choose to go to trial, they often face massive sentences if they lose. This so-called trial penalty punishes individuals for exercising their constitutional rights. And I'm really concerned about how the pressure to avoid the trial penalty impacts younger defendants and often women. Ms. Givens, I had several questions for you. I mean, some of these structural things that are driving mass incarceration, including the sentencing guidelines and such. Also, the fact that public defenders are often underfunded, overwhelmed, and cannot adequately protect their clients. Can you speak to the impact of having less than adequate legal resources for folks who are in our system?
Obviously, when we don't properly fund and support public defenders, we're not able to really deliver the services under the Constitution that people deserve. But I will say, as a federal public defender, I think that I have a lot of resources, and I want to just shout out that be mindful of the difference between state and federal public defenders. State public defenders are often saddled with higher caseloads, far fewer resources. As a federal public defender, I wouldn't say it's perfect, but I have a little more. And I think federal public defenders across the country deliver some of the best legal services around. It is that trial penalty, the mandatory minimums, and the discretion in sentencing taken away from judges and given to prosecutors that really informs our outcomes.
Right, and certainly the Philadelphia Public Defender's Office is legendarily wonderful, and you're absolutely right that often it's the state system. I believe Representative Deutsch on our committee has a bill, the Equal Defense Act, that was also sponsored by our current Vice President last term, so we know there's work to be done there. I'd like to direct your attention to something that's kind of mentioned obliquely in your testimony, which is the girlfriend problem that we've seen with mandatory minimum sentencing. Before coming to Congress, I had the opportunity to participate in the Clemency 2014 project and actually helped coordinate representation for 2 women who were sentenced to very long sentences as part of these ploys to get people to flip even though they weren't prime offenders. One of them was Michelle Miles, a first-time nonviolent drug offender. She received a mandatory minimum sentence of 30 years for conspiracy to possess and served 19 years before she received clemency. Basically, this was on the basis of her older boyfriend being someone who was running a drug ring. Similarly, Cindy Shank, whose odyssey became the subject of a Sundance Award-winning HBO documentary, also a young woman who was taken advantage of by an older guy who was running a drug ring, and prosecutors threw the book at both of them. Can you talk a little bit about how mandatory sentencing is disproportionately impacting women, particularly women of color?
Yes, well, mandatory minimum sentences are disproportionately impacting people of color of all genders. But I understand your question about, girlfriends taking the fall for their boyfriends involved in various trades, most representative drug trade. I think part of the problem is in the definition of cooperators and how we define cooperation and what type of things that we offer cooperators. And a girlfriend of a boyfriend who's involved in the drug trade can be linked to his primary activities, even if she has a very peripheral role. And that is something that is worth looking into, and how we can really separate the actions of a low level involved person to the decisions of the primary person. I think that
can I just get to one other thing, because my time is almost out. You did mention also the impact on juvenile defendants or folks who are younger, and how the pressure to plead creates issues. Can you speak to that as well?
Yeah, this is a big problem. And I want to say distinctly that when I'm talking about young people, I'm talking about 18 to 26. When we're talking about evidence-based sentencing, we have to remember that the data says that people between 18 and 26, they're not traditionally our view of juveniles, but they are in developmental adolescence. And these young people, it takes a whole bunch of different skills to present to them these long sentences and what that means for their life. And I think they get pressured and feel pressure to plea because they are overcharged. They don't have a lot of other choices.
I see my time has expired, but Madam Chair, I would ask unanimous consent to enter into the record a report from the National Association of Criminal Defense Lawyers entitled "The Trial Penalty, the Sixth Amendment Right to Trial on the Verge of Extinction and How to Save It."
Without objection, it is so ordered. Next, the chair recognizes the gentleman from California, Mr. Liu.
Thank you, Madam Chair, and thank you to all the witnesses who are here today, as well as for your expertise. I just want to first say that mandatory minimum sentences are stupid. And they're stupid because we stupidly force every fact pattern, every individualized case into these rigid little boxes that don't reflect reality. The whole reason we have judges and juries and prosecutors and defense attorneys instead of robots and computers is to provide individualized justice for each unique case. Mandatory minimums strip that away. It's had devastating consequences for society and overly harsh punishments. I'm a former prosecutor in the United States military. We didn't have mandatory minimum sentences for drug offenses. And we're talking about folks that fly fighter jets with weapons on them, drive tanks, sit in missile silos. We didn't have individualized or mandatory minimum sentences because we believe in individualized justice. So should the federal civilian side. And I look forward to working in the committee to eliminate mandatory minimum sentences for drug offenses. What I'd like to focus on today is pretrial detention. And Professor Barco, you had mentioned in your witness statement a section on pretrial detention, and you state that individuals detained pretrial are more likely to plead guilty than defendants who are not detained, and that pretrial detention also leads to longer sentences regardless of a defendant's risk, crime, or criminal history. Can you elaborate on why that is?
Yes, thank you, Representative Liu, for the question. I think that what we see when people are detained pretrial is they would like to leave. And so they will take what, it's an even more coercive plea bargaining environment than for someone who's not detained. You know, if you're thinking about fighting your case, but you're under detention, and you're offered any kind of time served sort of thing, people are more likely to take it. So they take worse deals, they get longer sentences as a result. And then the other thing we know about pretrial detention is that it is really disruptive on people's lives, right? If you take somebody who was working, their employer is unlikely to keep them, even if they're just detained a short period of time. It's not something that they're particularly forgiving about. Hey, I've got to serve out a little bit of time in jail. Can I still keep my job? You know, the answer is typically no. So they lose their jobs. They often get evicted from their housing. These are people that are living at the margins. They lose custody of their children. So it's an enormous disruptive event in somebody's life. So separate and apart from whatever they're accused of doing, when you detain them pre-trial and you take them away from all of those things, their job, their housing, their children, you can see why when they are ultimately released from that, it's harder to get on a path to stay law abiding. So they're actually at an increased risk of committing crimes than if we just kept them out in the first place and didn't detain them. And we have lots of evidence from the states now, places that are reforming their pretrial detention practices, where they're really lowering their detention numbers, and crime rates are going down, they're saving money. Again, it's one of those win-win areas.
I thank you, Professor Barco. I gather from your answer that you believe that pretrial detention reform, also known in some places as bail reform, would be a critical part of sentencing reform.
I think it's urgent, absolutely 100%.
Thank you. I also note that pretrial detention has skyrocketed in the federal system from 19% in 1985 to 75% in 2019. In addition, federal pretrial detention rates are much higher than states. We're at about 75% compared to 38% for states with large urban counties. And that's one reason I've introduced the pretrial reform bills. I have two of them, and I look forward to working with this subcommittee to get those bills marked up. And then I'd like to ask a question of Ms. Gibbons. First of all, thank you for your service as a federal public defender. Can you explain a little bit what the effect of pretrial detention has on some of your clients who, let's say, are unable to leave pretrial detention?
Pretrial detention in the federal system has a devastating effect. I agree with Rachel Barco wholeheartedly. It affects families, their lives, employment. But most importantly, I think we need to look at the data, which is if you release people pre-trial, they don't abscond and they're not a community safety risk, which are the only two questions that you're supposed to be answering at a pre-trial detention hearing. And the evidence just doesn't suggest that these people represent those two risks. We could save a lot of money and divert people into drug treatment and mental health treatment before detaining them.
Thank you so much, and I yield back.
The gentleman yields back. The chair recognizes the representative from Wisconsin, Representative Tiffany, for 5 minutes.
Thank you, Madam Chair. Ms. Barco, we're hearing a lot about that mental health is needed here. I think that's a pretty mental health treatment is a consistent message here in regards to drug problems, that type of stuff. So we had this great deinstitutionalization that happened, what was that, back in the 1970s? And did we make a mistake in not getting people mental health? Because perhaps changes should have been made in the 70s, but did we, by deinstitutionalizing, because I hear people in regards to the homeless problem, they speak frequently about those people have significant mental health problems, but they're not getting them, whereas perhaps they did get them earlier. Did we miss the mark 50 years ago?
You know, I think the deinstitutionalization movement, it was the right idea because these big mental hospitals were really abusive, awful places. They actually had a lot in common with what we see in prisons today. The idea behind it was supposed to be, they were supposed to be deinstitutionalized to community mental health facilities. So there were supposed to be community-based places for them to go. And that's where it went awry, is there was no replacement for what had been offered. So I don't think the answer would be a return to institutionalizing people, but I do think the idea of providing community-based care is critical. And that was the piece that was missing from that movement previously. And I think you're entirely right to draw the connection, though, between people with mental health needs and a hearing on sentencing, because, you know, for many of the people that we see cycling in and out of prisons and jails, they have an underlying mental health issue. And so you're not really doing anything by incarcerating them.
Sure. So we didn't have a replacement for what happened, which is classic. Ms. Givens, what I heard from you is you were saying the federal government is a problem in regards to this issue, that you would more effectively deal with this, or it would be more effectively dealt with if the federal government didn't do certain things. Is that correct?
The federal government, I heard your question as the federal government is a problem and they need to do certain other things. I'm not sure what you're asking me.
So when I heard your testimony, you talked about, I think, harsh mandatory minimums, some of the requirements that the federal government has in place, that they end up being counterproductive. Is that accurate?
I would agree.
Is that accurate?
Yes.
Yeah, okay. So I sure hope this committee, that we look at this in a way that is introspective and making sure that we're not creating problems for the states. Maybe this is something that we should defer to the states. I'm hearing about some success stories from states that they think they're handling it better. And this is classic, where we have the laboratory of the states, the 50 states, where they maybe more effectively deal with something like this, rather than trying to get this one-size-fits-all approach that comes from the federal government. Number 3, is it Frederick? I wasn't here for your testimony. Frederick, thank you. Can you, if we make these changes that you're calling for, can you assure us there will not be a spike in violent crime?
I think what you're seeing is that the things that we have currently have not assured that either. So I don't think, excuse me, I think you can't, what I can say is that the things that we are pushing for is an investment in communities and providing people support, and that those things are important as we move forward.
I respect the goals that you have laid out here for what we should try to do in laying out perhaps a roadmap to make this happen. But I can tell you, if we continue to see the unprecedented increase in violent crime that's happening in our cities right now, so my district, I'm in Wisconsin, but I'm right next to Minneapolis and St. Paul. Hudson, Wisconsin is 15 minutes away. They are seeing an unprecedented increase in violent crime in Minneapolis right now, and it largely affects minority communities of color. That's who's being hit the worst with this. I mean, I look at the feed on my phone each day, and I had 2 today, that regularly get these crime updates from Minneapolis, and it's unbelievable the number of people that are being harmed, whether it's carjackings, murders, and stuff like that. I think we have to make sure that we do a smart job here about this, because if crime continues to increase the way it is in our major cities across America, people are not going to stand for this, because this is what happened after the 60s and 70s, is people said, that's enough. We want our communities to be safe, and we could be right back here with the public saying, we want tougher, we want you to be much tougher on crime if we don't do this properly. Anyhow, my time is up, and I yield.
The gentleman yields back. We thank him for his testimony. We now acknowledge the Vice Chair of the Subcommittee, Ms. Bush from Missouri, for 5 minutes. You're recognized.
St. Louis, and I thank you, Chairwoman, for convening this important hearing. And let me just say, being tough on crime, let me start with being tough on crime is the reason why we're here today. It is not because social safety nets were being taken care of. It was the tough on crime work of people that even are in this chamber. So 50 years, that's how long our government has waged a war, not on drugs, but on people. Our people, they are not statistics. A lot of my colleagues, even here today in Congress, aren't where I'm from. They haven't seen what I've seen. The people and communities harmed by this racist, white supremacist war on drugs, those folks are my neighbors. They're my friends, they're my classmates, they are my loved ones. I will never forget how in a 2-year window as a young person, I lost 40 to 50 friends. Imagine losing friends or community members so frequently that loss and trauma become your norm. In fact, I lost more friends to the war on drugs than not. I had a very, very close loved one of mine who was killed, shot straight in the head because of this nightmare. For those of us that lived through this war, we lived through daily and tragic deaths. What the war on drugs ignited was an actual warfare on our streets. Our grandparents were forced to put their homes up for bond, and when the government threw us in jail and left us without any social safety nets, it was that this was what was needed. But no, many grandparents were forced to become guardians because the war on drugs devastated an entire generation of parents. Children were forced to be caretakers for their parents who fell victim to the cycle of abuse. I watched young boys fall into the trap of selling drugs as a means of survival. Youth joining gangs as a way to secure their homes and their streets from police violence. I know because I was a part of that. It's not something that I read or that I heard, like some folks on here. I saw young women and girls unwillingly fall victim to trafficking, abuse, and exploitation to survive this war on drugs. As a young child and a young adult, I didn't think I had a voice to do anything about what I was seeing. But now, as a congresswoman and as a nurse, I can speak for all my friends whose lives were cut too short. I can speak for those friends who are still behind bars even to this day. And I can say unequivocally that the war on drugs was a failure of policy. It was a failure many leaders in this very chamber are responsible for. Ms. Frederique, thank you for your thorough testimony and providing solutions. The war on drugs has not meaningfully reduced drug use. In what ways has it worsened drug use and overdose deaths?
Thank you so much, Congresswoman, for your question. Unequivocally, our choices around policy, our draconian investments, our focus on incarceration and criminalization have not only not deterred people from using drugs, but they have also made drug use more risky and more dangerous. Prohibition itself has made our drug supply risky and dangerous. Our choice, that was a choice, to create prohibition and to really push and focus on criminalization has made our drug supply poisoned. And what we are seeing with the overdose rates is that people, one, don't have the education that they need in order to understand drug use and to make sure that they don't die, which is basic. Two, our drug supply is poisoned because people are adulterating it because of the incentivization of prohibition. And three, our communities don't have the resources necessary to navigate addiction because we are bloating our criminal justice system as opposed to the public health infrastructure that people need to navigate addiction. As a social worker, it is very clear to me that we need community supports and resources to navigate people's choices around risky drug use. Our focus on criminalization not only makes it difficult for people to ask for help or to get them, and it also makes it really difficult for us to control the kinds of substances that people are using.
Thank you, Ms. Frederique. Ms. Barkow, you have written extensively on the role of the president and how the role he can play in reversing the harms of the war on drugs for those still serving time. Can you talk about these proposals?
Yeah, whatever you all do in Congress, and I urge you to do as much as you can, the president can use the clemency power to reduce sentences. So anyone, for example, who's serving a sentence under any of these mandatory minimums that's too harsh, the people who are on home confinement that someone asked about earlier, keeping them out, the president can do all that through clemency. There's no reason to send any of those folks back. A blanket clemency order would keep them home. He can use the clemency power to reduce these draconian drug sentences that people are serving, and I certainly hope that he uses that power.
Thank you very much. And I'll close here. For years and years, our communities were duped. Our communities were told that these criminal policies were necessary to keep our streets safe, but we know that that was a lie. We know that these policies made substance use health issues even worse. And I implore my colleagues to join us in legislating to promote health and not perpetuate harm. Thank you, and I yield back.
I thank the gentlelady for important questions, and I thank her for yielding back. Now recognize the ranking member, Mr. Biggs, for 5 minutes of questioning.
I thank the chair, and this has been a very interesting hearing, and I really thank you for holding this hearing. This is an important hearing, and as a person who practiced law in the criminal field for a number of years and tried many cases, I will tell you that I think that it's interesting to me that we have so much of what I've heard I find fascinating. I think there are things that we can have points of agreement on, and if I could at some point, I would encourage us to be able to sit down, put aside our partisan differences, and see if there was some way to find concord, at least in certain areas, that we could move forward. It's very difficult to do. I would just want, because, and I have to respond to something that was just said in the last speaker, that these were institutionally racist policies. I just point out in 1971, New York had a huge heroin epidemic. It was just a terrible problem in the early 70s. And then Congressman Rangel from Harlem urged then President Nixon to ramp up drug fighting efforts more aggressively and said, quote, "We could bring a halt to this condition which is killing off American youth," close quote. That's what he told President Nixon. I don't think this was done intentionally on a racist basis. You know, can I have a point of order? That's, Madam Chair, that's absurd. That is absurd.
Mr. Biggs. It's Mr. Biggs' time.
And I've asked for my time to be restored to where it was before I said.
Your time is being restored. And do you wish to yield to the gentleman for his
No, I don't. I don't, Madam Chair. I will not yield to you.
We'll provide you with that at a time.
Thank you. So, I mean, the reality is, that's what I'm talking about. That kind of interruption prevents us from being able to set aside partisan bickering and get to where there's concord to move things forward. I'll tell you about a case where a client I represented one time with regard to drug abuse. This individual was charged. He was probably the most respectful defendant I'd ever had an opportunity to work with. Very respectful, very kind, very gracious. His charge was first-degree murder. While under the influence of drugs, he had gone into a home of a man that he had met and killed him. He strangled him. There was very little defense to that. I mean, that's what he did. He was while under the influence of drugs. We had to wait to do the trial because while under the influence of drugs, he'd gone into a restaurant with two friends and semi-automatic weapons and robbed the entire restaurant. We had to wait for that trial to be completed before we could go forward, and we had to move, the motions that were necessary regarding that. I tell you that because I asked him what he thought the root of his problem was. He said it was drugs. He said it was clearly, when I was under the influence of drugs, it just messed everything. And we had an extensive talk and conversation about that. It ended up ruining his life and many others. And I tell you that because I do think drug use and trafficking can have very serious consequences, tangential to personal use. But I was taken by something that Mr. Underwood said about training individuals who are going to be coming out so they don't recidivate. The Arizona Department of Corrections, and this is one thing I think Mr. Tiffany was correct on, I think the states have gotten way ahead of the feds on a lot of sentencing reform. They use private sector groups. I'll give you an example. They use the Home Builders Association. That Home Builders Association provides training in the trades, whether it's framing, plumbing, et cetera, to build homes, commercial facilities. Why is that important? Because Arizona can never find enough. There's always employment available in those trades. So we want them to be able to. We want individuals to be able to get out, be able to find employment, and go forward. We have unique problems. Every state does. I think in the comments that Mr. Malcolm indicated, my note at the beginning of his comments after listening to him was that, and I think a lot of you have shared that, is an individual charged with a crime, those are particularized situations and circumstances for that individual. And sometimes the larger view, the generic view, doesn't take those into account. And I'll have more to say on this later, Madam Chair, and I'll yield
back. We thank him for take a moment of personal privilege, indicating that we may have some common ground, and we do thank you for acknowledging that. I think it is now appropriate to yield to Mr. Cohen for 5 minutes.
Thank you, Madam Chair. And I should not have laughed, except I had to, because I was reading a quote from John Ehrlichman, a top Nixon advisor and former Watergate co-conspirator, who later revealed the true reason for the war on drugs in a 1994 interview with Harper's Magazine. Mr. Ehrlichman didn't bring up Charlie Rangel. Mr. Ehrlichman said, "You want to know what this was really about? The Nixon campaign in 1968 and the Nixon White House after that had two enemies, the anti-war left and black people. You understand what I'm saying? We know we couldn't make it illegal to be either against the war or black, but by getting the public to associate the hippies with marijuana and blacks with heroin and then criminalizing both heavily, we could disrupt those communities. We could arrest their leaders and raid their homes, break up their meetings, and vilify them night after night on the evening news. Did you know we were lying about the drugs? Of course we did." So that's a pretty laughable thing to follow up with Charlie Rangel influenced President Nixon to start the war on drugs. That was absurd. And if you go back into history with Harry Anslinger, which is back in the 30s, it was all about African Americans and Mexicans. It was racist, 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 and always has been and still is. The war on drugs is a big failure. Just say no is a joke, a simplistic answer to a difficult situation. I've worked, I think was it Barlow? Somebody brought up about commutations and sentencing. I've got pardon legislation to amend our pardon power to take away the ability to pardon your cronies, your family members, your associates who worked with you in your campaign, your people in your administration, which is basically what the previous president did. He'd had a few cases where he took care of a few people who knew a lady that was originally from Memphis, moved to Arizona, and somebody she brought up, but he didn't go through and try to take care of a bunch of people sentenced for long drug sentences. He didn't do that. He took care of Manafort, and he took care of Flynn, and he took care of Roger Stone and all those criminals. We need to change our pardon power and make it to where it is mercy and justice and not taking care of cronies and covering up crimes, which is what we just experienced. I was not totally enamored with what President Obama did, but at least he got 1,800 people out of the criminal justice system, people he didn't know. They weren't favors. He set up a system that was rather rigid and lengthy, but a system, and he didn't get to probably another 8,000 people who at least deserved justice and should have had their sentences commuted because it was such a difficult process. But at least 1,800 people got out, and it was something pretty amazing in American history that a president pardoned people who he didn't know, who never made a campaign contribution, who never covered up a crime for them, but he pardoned them because they did meet some criteria that showed they were in prison unnecessarily in too long a period of time, and they were drug sentences. We need to use the pardon power early on to help filter out people who shouldn't be in the criminal justice system. We need to use compassionate release and get rid of older people and sick people and whatever, and do whatever we can. Mr. Malcolm, in your testimony, you said you don't like to call the drug problem a victimless crime or whatever, because of the fact that in the chain of distribution, there's the likelihood of there being violence and guns and all that stuff. And that's true. But do you still think that because of that the people who are possessing should be penalized harshly like we do it?
No, so what I said in my written testimony is that I'm always uncomfortable with the phrase nonviolent drug offense because there is inherent in any drug deal the risk of overdose, in addition to the fact that a lot of it is gang-related, and there is a lot of violence that comes from that.
Let's take marijuana. Let's take marijuana. Would that a person possessing marijuana, he's not going to overdose?
I'm going to separate out. I mean, so all I'm saying is that people who just routinely use the phrase nonviolent drug offense doesn't sit well with me. That is a different issue from how long we should incarcerate people and how long we should punish them. As I said, I was in favor of the First Step Act, which cut back on mandatory minimum sentences for repeat drug offenders, and I am open to reforming sentencing laws. That's what I have said in my testimony.
Okay. Let me ask you this. Mr. Chabot mentioned it in his questioning, and Mr. Chabot's my friend, but he brought up the idea of, does defund the police hurt the police's attitude? And he stressed all the defund the police stuff, which Republicans do, and that's one of our problems. Most most Democrats, I'd say that less than 2 hands can you count people who are for defunding the police. Do you think that Republicans who voted against the Congressional Gold Medal for police and other policemen, and there were more than, I think, 21 of them voted against, more than 21, voted against giving them a Congressional Gold Medal. Do you think that hurts the feeling of the police about their support and their attitudes?
Congressman, that's a political question that I've given no thought to. I certainly applaud the heroic efforts of the people who kept you safe on January 6th.
And what about somebody, and one of our members said that the officer who shot Miss Babbitt when she tried to break through the glass window that had been broken and come into the speaker's lobby, he called that Capitol policeman an assassin. Do you think that hurts the people in the Capitol Police Department's mood and feeling?
I've heard that view expressed. I do not agree with that. The officer who killed Ms. Babbitt was clearly protecting you. We were about to have a group of people breaking through a window. Okay.
Thank you, sir. Sure. Thank you.
Gentleman's time has expired. Thank you so very much. Take a moment, members, to first of all acknowledge members who desire to be here. Again, members of this committee, I want to thank you for being here. Representative Bass, Representative Demings, Representative McBath, Representative Dean, Representative Scanlon, Representative Bush, Representative Cicilline, Representative Liu, Representative Correa, Representative Escobar, Representative Cohen. These are all faithful members, and in some ways, members were called away. I want to acknowledge them. Representative Biggs, of course, our ranking member, Chabot, Representative Gohmert, Stubbe, Tiffany, Representative Massey, Representative Sparks, Representative Fitzgerald, Representative Owens. My subcommittee is a very faithful committee. I want to acknowledge that members had a number of obligations, but we thank them for their presence. Mr. Biggs, did you want to take some follow-up questions?
I unfortunately have to go, but I want to submit them. Madam Chair, I unfortunately have to go. I'd like to submit this article for the record, being covered in the record, if that's possible.
Without objection, so ordered.
Thank you.
Thank you. And you have a very effective substitute, so thank you. I'm going to take a moment to submit some statements into the record that I think are appropriate. First of all, without objection, I'll be submitting a statement from the Leadership Conference into the record, submit statement from the ACLU into the record without objection. Then an article, They Let People Die, U.S. Prison Bureaus Deny Tens of Thousands Compassionate Release During COVID. Mr. Underwood indicated that he was released by his own record, but also under that process. The data shows officials approved fewer applications during the pandemic than the year before, despite risk from the virus. Asked unanimous consent to submit that without objection. Drug reform advocates call Supreme Court ruling, which just recently came out on crack sentences, a shocking loss. And then an article in The Hill from Mr. Lowenstein, Why the War on Drugs Must End. There is a dangerous myth that it is over. In reality, the drug war has never been more ferocious, targeting minorities and the most vulnerable in the U.S. and abroad. Ask unanimous consent to have those submitted into the record. Members, I have one or two questions, and I will then conclude. So let me just quickly ask Ms. Nelson that we know the 70s marked the formal beginning of mass incarceration. We have seen the results of mass incarceration, of what transpired with mass incarceration. And so the question that we have is, why is it important to remember and consider that history, which is evidence of mass incarceration, when undertaking sentencing reform?
Thank you for that question. I think it's important to, and many of the questions and the colloquy today has touched on the history of when we started going down this path in the 70s to the 90s. It was a period, and as I said in my testimony, right after the civil rights, the achievements of the civil rights era, there was a rise in crime, but it immediately became politicized and racialized in terms of sort of conflating growing crime with criminality of non-white people. And that allowed us to come down on people in a very harsh way. And I think now, and it's certainly we've been hearing about it throughout this testimony, What are the lessons that we've learned from that period? How can we not make those same mistakes, both as we undo the war on drugs and think again about what we're trying to do when we sentence people? And the framework that we put forward is that when we're sentencing people, we have to have a reason for doing it. We have to actually need to create actual safety. We have to repair harm, and we have to promote racial justice. And an overly harsh mechanism for sentencing does none of that. There's been lots of testimony from several witnesses about how harsh sentences do not deter crime. And there has been testimony about where we are now in terms of rising crime. And I think I cannot say strongly enough that as we are in this period, we can learn from what we did wrong in the 70s through the 90s and take an evidence-based approach to both how we deal with being proactive about crime, and then once crime has occurred, what is the appropriate sentence? It should be a sentence that repairs the harm, not a sentence that holds people in for too long and to no effect.
Thank you very much. I think it's clear the challenges we have. Very quickly, to Ms. Givens, you had an important statement in your testimony that what we're doing is really erasing an entire phase of life for an entire generation. We know that brains do not mature until the age 25. Explain what this process of mass incarceration and mandatory minimums does to your defendants, particularly in the age 18 to 26, and again, how destructive that is.
Quickly, I guess in a nutshell, I would say that what it does is it doesn't give young people the opportunity to do some of the things that Ms. Nelson was just speaking about. It doesn't give them the opportunity to repair and recover. And the brain development piece is so hopeful and so important because what we know from data is young people's brains develop and they respond in a shorter time. So they don't need these long sentences to make a U-turn in their life. It takes away their education, takes them away from their family. It actually increases trauma. The act of incarcerating a young person increases trauma, and you really take away connection, mental health, and superimpose on them hypervigilance, anxiety. They don't continue to develop self-esteem, and all of these things will follow them for the rest of their life. But most importantly, it takes young people away from the ability to become good income earners because we are wasting 5, 10, 20 years of their life where they could get a skill and contribute to society. So,
and as a federal defender, you see this all the time?
All the time. It's why I feel like this about it. I see it all the time.
Ms. Frederique, I think you might remember a recent news story regarding teens in Ocean City simply trying to enjoy themselves. They were vaping and came across, or law enforcement came across them, sizable amount of violence, violating the anti-vaping law, obviously. I guess one might say that it was considered a drug. How does these kinds of laws then wind up with probably violent encounters and young people losing their freedom and also being, unfortunately, violently confronted?
Thank you for that. So what I would say is what we saw in Ocean City is something that we see all across this country, where people use substances as an excuse, as a pretext or justification for law enforcement violence against young people and people of color. And it's one of the biggest reasons why we need to move away from the current war on drugs, because it creates the space for these encounters. So it gives excuse for law enforcement to disrupt the fun that young people are having. And I think it's really important to recognize that there are only certain young people that are able to take up public space and to have fun and to be joyful and to be loud and rambunctious. And then there are other young people that take that time and take up that space and then are met with the state actors like law enforcement engaging them in ways that can often escalate and turn into violence. And drugs, be it things that are legal or illegal, drugs in general, so tobacco, alcohol, substances, are often used as a pretext for the engagement or justification for the escalation. And so one of the things that is super important for us is to figure out how do we remove those tools so that we can give young people more time to experience life, freedom, liberty, and autonomy without the constant over surveillance that we see that the state uses.
Thank you very much. Mr. Underwood, because you're so powerful, I'm going to give you the last word. Mr. Underwood, can you turn your mic on? I'm giving you the last word. You had a sentence of life, is that correct?
Yes, ma'am.
Was that life without parole?
Yes, ma'am.
In the course, if you don't mind, in the course of your being contrary to the legal system, did you have any act of, where someone lost their life?
In my case?
Yes.
Well, I was accused of being the head of a drug ring that.
Right. But your actual actions did not.
No. And
your actual, but you got life without parole.
Yes, ma'am.
And so if there was not a court intervention and a number of other things and your basic rehabilitation and goodness, you would still be there.
Absolutely.
Gentleman with a suit on and tie would still be there.
Yes, ma'am.
And so just my final question to you, is the war on drugs, mandatory minimums, how much life is being lost, how much people value here to this nation is being lost by those under the mandatory minimums in our prisons today, particularly our federal prisons?
Well, mandatory minimums, Chairwoman, are a travesty because they don't allow for judges to consider the individual themselves. I can speak for myself. I made a Sixth Amendment challenge to the application of the federal sentencing guidelines to my case. What that means is, when I went to trial, I understood that the Sixth Amendment was instaurated in 1791. I went to trial in 1989, but I didn't have Sixth Amendment rights because of mandatory minimums. And I was one of the first persons that they used this case, Macmillan versus Pennsylvania, against. And long story, this is the condensed version. After Macmillan, in 2002, Macmillan came out in '86, was one of the first persons that they experimented with. Macmillan, sentencing factors, the judge can do this. No, the jury doesn't have to find anything. They don't have to find you guilty of the most heinous acts. If they say you committed murders, then it should have been a jury question. No, the jury don't have to find you guilty of that. Or they say you sold drugs and you are facing a 10-year sentence, and now because of mandatory minimums, you got life with no parole. Well, that should be a jury question. No, juries don't have to find. This is drug. I, as a judge, these are sentencing factors. Live with it. That's what they did. That's fine. Time went on, 25 years passed. And this is the irony of doing a lot of time, because you have to understand that your children, your grandchildren, your friends, people that love you, that want to help you, that don't know how to help you, the reality is, for them, life is like this, because you're over there, and life is over here. And if you have families grow, like the Congresswoman said, friends and families, you lose along the way. But in my case, 25 years went by, and Al-Yin, we say Alain, but it was Al-Yin, it's pronounced Al-Yin, that came out in 2013, 570 U.S. 99, 2013, it came out. And it said, you know what? You were right. Mandatory minimums, in order to get to the ceiling for maximum, you have to stand on the floor. So you have to be found guilty of every element of the offense to get the mandatory minimum. I didn't get that option under the Sixth Amendment, which I have 6 cases in the law books, 6 actual published opinions. 3 of them I put there myself. Yeah, so once this happened with the law, and I figured, well, okay, I was going to go home at some point. The reality of all of this is that they never made any of this retroactive. So I digress. Let me go back a little bit. 1999.
If you can summarize.
Richardson. Yes, ma'am, I'll summarize it like this. Richardson would have got me down to 20 years because that was a direct 848 case. Because not only did I have racketeering, that I had a drug conspiracy, but I had continued criminal enterprise. But I was never given the opportunity to have the jury find me individually guilty of any of those things. I just had a general jury verdict, and the judge said, whatever they say, that's, yeah, you're guilty of that. And I made these objections at trial, at sentencing.
You lost a good part of your life.
Yeah, a significant part.
Well, you have made your repentance to society, and I assume to yourself and
yes.
4 children that you
My
have.
children.
Their children
My
are in
family.
good stead. Your children are, you're proud of your children?
Absolutely, yes, ma'am. Absolutely, Chairwoman, absolutely.
Well, let us learn from where you are today and what might have happened to those who are not lucky enough, or how should I say, astute enough to have been in this chair where you are today.
Yes, ma'am.
That are now languishing. And I hope that this committee, in a bipartisan manner, with Mr. Biggs, a ranking member, has made some very important points. Our colleagues have made some very important points, that we can come to some consideration of what is the best approach for this scourge of drugs that was utilized to be a scourge on people and families and humanity. Forgive me for my extended comment. The ranking member is very kind in his indulgence, and so are members, but I want members to know that we're going to move ahead, because this is the moment that we must deal with this question. And I think there are a lot of minds here that can contribute to the solution, and I hope the minds will be both Republicans and Democrats. With that in mind, no further comments from my members. This hearing on the undoing the damage of the war on drugs, a renewal call for sentencing reform, is now herefore adjourned. Let me thank all the witnesses for their outstanding testimony. Thank you.